compared with their federal agency counterparts. They can't rely on the U.S. taxpayer to cover either their compliance or their cleanup costs. They also can't always choose their own remediation options, and they can't fall back on the defense of sovereign immunity when they are taken to court. While those private sector companies focus on making a profit while complying with the environmental protection standards, the defense and energy departments focus on national security. And national security can be a messy business involving everything from motor oil to munitions waste. And even national security is no excuse for leaving a mess in your neighbor's backyard. As we drill down into specifics on an agency-by-agency basis, we'll learn that some of our federal partners are more successful than others in juggling these dual responsibilities to their core mission and to protecting land and water. The agency's challenges are not uniform, and neither are their budgets. We have 4 objectives today. The first one is to get a detailed update on where agencies stand meeting their good neighbor obligations. The second one is to find out what the challenges are and how those challenges vary from agency to agency. The third one is to understand what the resource management relationship is between each of these agencies and the EPA. And finally, to get GAO's perspective on who's doing a good job, who's not, and what they can do to improve. Next week, a second panel for this hearing will provide the state perspective. Under our system of government, states have primary responsibility for protecting their own natural resources, including land and water, from environment degradation. But a state's challenge is made more difficult, if not impossible, to meet if the entity responsible for the environmental mess is a federal agency, with all the power that status implies. After the episode last month in Colorado with the release of contaminated water into the Animas River, I wouldn't be surprised if some in our audience thought first of EPA when they heard the phrase federal agency responsible for an environmental mess. But the Colorado mine release is not the focus of this hearing. Since we first got the news of the blowout, our committee has been looking into the Colorado mine incident on a separate track from this hearing. At the beginning, we had lots of questions and almost no answers. Gradually, we've been piecing together the facts as best we can. We're not finished yet. I trust our friend Mr. Stanislaus and everyone in the administration will cooperate with our committee as we pursue that inquiry. Correct, Mr. Stanislaus? Yes. And he shakes his head yes. Thank you. Today, I hope that we can focus on the federal facilities issue and whether important agencies such as the Department of Defense and the Department of Energy are good neighbors and good stewards of the land and water that they touch wherever they have a presence. And I'll just end with, my background is also as a military officer, understanding national security and the challenges that faces. So the balancing of that and also being a good neighbor to our folks is very important to me. But I'd also want to say I appreciate the work that the DOE and the Department of Defense does in protecting our citizens. With that, I yield back my time and yield 5 minutes to the ranking member. Unless someone else wants my final, I yield now 5 minutes to the ranking member, Mr. Tonko.
Thank you, Mr. Chair, and good morning, and thank you to our witnesses for participating this morning. And I thank the Chair for holding a hearing on this very important topic. Congress enacted the Comprehensive Environmental Response, Compensation, and Liability Act, commonly known as Superfund, some 35 years ago. But communities across the country are still dealing with the legacy of toxic waste. After a rough start, the Superfund program has had success in containing and cleaning up serious contamination problems in many of our communities. But there is still much work to do and too few dollars available to do it. The good news is that sites are being cleaned up. When sites are cleaned up, the surrounding community benefits from a cleaner, healthier environment, and returning abandoned, contaminated land to productive use improves the local economy. In addition to the sites on private or state land, there are many Superfund sites on federal land. The federal government operates facilities across our country on millions of acres of land. Some of the federal site contamination is due to the government's activities. But there are also many areas where mining, drilling, and industrial activities by private parties took place decades ago, leaving a legacy of contamination. The federal government is subject to the Superfund law, and the government spends billions of dollars annually to clean up hazardous contamination at federal facilities. A few years ago, I asked the Government Accountability Office to look at the status of cleanup activities on federal lands, and to focus on the agencies and departments other than the Departments of Defense and Energy. These department sites are generally well known and have received considerable oversight and attention. The situation for the United States Department of Agriculture, the Department of the Interior, and other federal agencies was less clear. Under the Superfund law, federal agencies are required to identify, assess, and clean up contamination on the properties that they administer. But cleanups cannot begin if sites have not been identified and characterized. As Mr. Gomez and his team found, this first crucial step has not been completed in the case of these other departments. And because of the nature of the sites on Department of Interior and Department of Agriculture lands and the limited budgets for these activities, it does not appear we will have a complete, reliable inventory in the near future. We spend a lot of time these days worrying about how much the government is spending. I worry about that as well, but I also worry about how we are distributing these dollars that we do spend. Across-the-board cuts and arbitrary caps are preventing us from doing some of our most important and difficult tasks, setting priorities and ensuring that we are providing funds to programs that deliver sustained benefits to our citizens, and returning contaminated land to productive use, preventing pollution migration, and reducing people's exposure to dangerous toxins certainly is a sustained benefit. With the passage of Superfund, we made a commitment to identify and clean up contaminated properties. We should fulfill that commitment. I don't know that new legislation is required to do this. I do believe that additional oversight of this program, however, would be very useful. This hearing makes an important contribution to that effort. Mr. Gomez, thank you and your team for your work on this issue. You have given us a lot to consider and provide some constructive recommendations. I do appreciate the opportunity for the subcommittee to examine our Superfund program. The citizens living in communities with these sites are anxious, and they're anxious to have them cleaned up and returned to safe, productive use. The responsible parties, whether public or private, want to accomplish those cleanups in a cost-effective manner. These are goals that we can all support. So I do hope to work with you, Chairman Shimkus, and the other members of the subcommittee to achieve these goals. And I thank all for participating in the hearing this morning and next week, and I look forward to your testimony on what is a very important issue. With that, I yield back.
Gentleman yields back his time. I'd like to submit, with unanimous consent, a statement of record from Chairman Upton for his opening statement. Is there anyone on the majority side wishing to seek time? Seeing none, Chair now recognizes Ranking Member of the full committee, Mr. Pallone, for 5 minutes.
Thank you, Mr. Chairman, and our Ranking Member for calling this hearing on the Superfund program. Superfund has been an incredibly important tool for protecting public health and the economy in my home state of New Jersey and throughout the country, and thousands of contaminated sites have been cleaned up and revitalized, including many former federal sites. As successful as Superfund has been, there's still so much important cleanup work to be done. I expect we'll hear from today's panel about the staggering number of abandoned mine sites, just a subset of federal sites, and an even smaller subset of contaminated sites nationwide. And I hope that my colleagues on the subcommittee will join me in working to ensure that EPA, other federal agencies, state and local communities have the resources needed to get these cleanups done. Superfund sites are contaminated with toxic substances that can make their way into drinking water wells, creeks and rivers, backyards, playgrounds, and streets. Communities impacted by these sites can face restrictions on water use and recreational activities, as well as economic losses as property values decline due to contaminated land. In the worst cases, residents of these communities can face health problems such as cardiac impacts, infertility, low birth weight, birth defects, leukemia, and respiratory difficulties. The major environmental laws that are truly the powerful legacy of this committee have consistently held that polluters must pay for environmental harms. The principle is the heart of the Superfund program and should be preserved. For federal facility cleanups, that means that we in Congress have a duty to ensure funds are appropriated to cover cleanup needs. For private facilities, that means we have a duty to reinstate the Superfund tax and stop charging taxpayers for cleanups. In 1995, despite opposition from myself and other Democrats, a Republican Congress allowed the Superfund tax to expire. Before its expiration, the collected taxes were placed into a Superfund trust fund that was used for the cleanup of so-called orphan sites, where the party responsible for the pollution either no longer existed or could not afford the cost of the cleanup. The thousands of abandoned mines across the western United States are examples of such sites. Without those revenues, important Superfund cleanups have been delayed, the backlog of sites needing cleanup has grown, and the costs have shifted to the taxpayers. As many of you know, I've routinely introduced legislation, the Superfund Polluter Pays Act, which would replenish the Superfund Trust Fund by reinstituting the taxes that the oil and gas companies paid between 1980 and 1996. The legislation reinstates a 9.7 cents a barrel tax on petroleum, a tax on 42 chemicals, and a corporate environmental income tax of 12% on taxable income in excess of $2 million. This would help ensure that the EPA has sufficient funds available for the costs of investigation and cleanups of these toxic sites. Reinstating this tax should be a part of any conversation we have in Congress about Superfund. But the tax itself is not enough. We need higher appropriations for federal agencies with responsibility for cleanups, and we need financial responsibility requirements to stop the proliferation of abandoned mines and other orphan sites. Under Section 108 of Superfund, EPA has been working to establish such requirements for hard rock mining and eventually for other polluting industries. Financial responsibility requirements would ensure that any company undertaking the dangerous practice has the resources necessary to cover the costs of anticipated cleanup needs. Republicans have blocked these requirements in recent years through appropriation riders, a practice that I hope will stop in the wake of the Gold King mine spill last month. Removing public health hazards by cleaning up contaminated sites is incredibly important for the surrounding communities. Cleaning up toxic Superfund sites not only reduces human health risks, it helps create jobs during the cleanup, and through newly uncontaminated and productive land makes it ready for redevelopment. So we should all support cleanup efforts and should ensure that those efforts are funded. Again, I look forward to today's testimony. I thank both the chairman and Mr. Tonko for calling this hearing. I yield back.
Gentleman yields back his time. And now I'd like to recognize, and I'll introduce you when your time comes to speak. First would be the Honorable Matthew Stanislaus, Assistant Administrator, Office of Solid Waste and Emergency Response for the U.S. Environmental Protection Agency. Your full statement's in the record. You have 5 minutes, and welcome back.
Okay, thank you. Chairman Shimkus, Ranking Member Tonko, Congressman Pallone, and members of the subcommittee, I'm Matty Stanislaus, Assistant Administrator for the Office of Solid Waste and Emergency Response. Again, thank you for inviting me here to talk about the Superfund program. In specific, I'm going to talk about the federal facilities component of it, which is the focus of this hearing. Now, the cleanup of federal facilities is led by the federal agencies who have delegated authority with properties under their responsibility, with the EPA having a discrete role, which I will get into it in a second. CERCLA Section 120 provides a framework for identifying contaminated federal facility sites, assessing actual or potential environmental risk from these sites, and ensuring cleanup and other actions to protect public health and the environment. Under Section 120, federal facilities are required to comply with CERCLA in the same manner and to the same extent both substantively and procedurally as private entities. Section 120 includes provisions and timetables that apply to federal facilities only, including requiring the EPA to establish a federal agency hazardous waste docket, requiring completion of a preliminary assessment by a federal facility after docket listing, requiring a federal agency to commence a remedial investigation and feasibility study within 6 months of that facility being placed on the national priorities list, and requiring that the EPA and the federal facility agency enter into an interagency agreement referred to as a federal facility agreement at all NPL sites. Also, there are specific provisions that govern the transfer of federal facilities to private entities. Under Executive Order 12580, federal agencies are designated as the lead agency for carrying out many of CERCLA's statutory requirements at their facilities. However, EPA retains the final decision authority over a small subset of these. These are remedial action sites at national priorities list sites. If the federal agency and department and EPA are unable to reach agreement on the selection of remedial action at these NPL sites. EPA's administrator makes the final decision. The shared responsibility of program implementation under CERCLA has unique challenges for EPA and other federal agencies, but has generally worked effectively. Currently, there are 157 final federal facility sites on the NPL, and another 17 federal sites have been deleted from the NPL. Approximately 80% of these 174 sites are DoD component sites. The CERCLA framework has worked effectively for helping to ensure appropriate cleanup for more than 20 years. Moreover, because states are often parties to a federal facility agreement, and state laws and regulations may apply to state site cleanups, states and EPA work together to ensure that the NPL cleanups meet statutory requirements, protective of public health and the environment, and incorporate pertinent state requirements. EPA is engaging with other federal departments and agencies on a range of activities to maintain and accelerate cleanup progress of federal facilities. For example, we are working collaboratively with DoD on tools for advancing geophysical classification to allow for more accurate and efficient cleanup of munition sites, a fairly significant issue, improving site-level data quality, and resolving technical issues associated with emerging contaminants. Ensuring that people have environmental information about their communities is the top priority of my office. In 2010 and 2011, as part of ongoing efforts to enhance community engagement, my office reached out to diverse stakeholders through the Federal Facility Dialogue as well as the federal agencies represented here today. What we heard from stakeholders is that there's a need for more transparent and easily accessible information on cleanup progress and long-term protectiveness. We've begun to move forward on some of these issues. For example, the past 5 years, EPA has led an interagency working group to make improvements to the 5-year review process that would foster greater transparency and participation from impacted communities. When wastes are left in place, EPA assesses whether the remedies continue to be protective of public health and the environment through a 5-year review. And we are continuing to modernize the federal agency hazardous waste compliance docket and exploring ways to make the program data more accessible to communities and other stakeholders as required by CERCLA. In 2012, in EPA, in collaboration with other federal agencies and departments, we completed a federal facility site evaluation project. This project evaluated the disposition of 514 federally owned sites that EPA identified as potentially stalled in their progress. Through this process, EPA has been able to make an activity determination on 491 of the 514 sites on this list. Initiatives like this allows EPA to ensure that federal facility information is up to date and communities have the most pertinent information on that site. I will close and looking forward to your questions.
Thank you. Chair now recognizes Mr. Mark Whitney, Principal Deputy Assistant Secretary for Environmental Management with the U.S. Department of Energy. Sir, you're welcome. You recognized for 5 minutes.
Thank you, and good morning, Chairman Shimkus, Ranking Member Tonko, and members of the subcommittee. I'm pleased to be here today to represent the Department of Energy's Office of Environmental Management and to discuss the Comprehensive Environmental Response Compensation and Liability Act. The Environmental Management Program was established in 1989 with the mission to clean up the largest and most complex nuclear waste sites in the world as safely, effectively, and quickly as possible. This involves some of the most dangerous materials known to humankind, and it is no simple task. But EM has completed cleanup activities at 91 sites across 30 states since our inception, leaving remaining cleanup work at 16 sites in 11 states. That is approximately $150 billion worth of cleanup work completed since the inception of the program. Sites like Fernald in Ohio and Rocky Flats in Colorado have been cleaned up and are now wildlife preserves. We have decommissioned and demolished more than 2 million square feet of excess facilities and removed all EM special nuclear material from the Idaho National Laboratory. We produced nearly 4,200 canisters of vitrified high-level waste at Savannah River Site and West Valley sites combined, and we've closed 6 underground storage tanks at the Savannah River Site. We demolished the K-25 building at the Oak Ridge site, which was once the largest building under a single roof in the world. The federal government's investment in EM is resulting in safe and secure nuclear waste and reduced risk to the American people and the environment. One of the greatest success stories of the program is the cleanup of the Rocky Flat site, which is listed on the national priorities list, and cleanup was guided by a tri-party interagency agreement. In October 2005, EM completed the cleanup significantly under estimated cost and schedule. A number of factors were important contributors to the success of the Rocky Flats cleanup, including a collaborative working relationship with the regulators, both the state regulators and the Environmental Protection Agency, an incentivized and motivated management and operations contractor, consistent and reliable budget appropriations, a closure managed as a finite project, involve stakeholders, and engage workers and public. The Department has a balanced approach under the regulatory frameworks of the applicable environmental regulations, including CERCLA, also the Resource Conservation and Recovery Act, or RCRA, the Atomic Energy Act, and the National Environmental Policy Act. And this guides and directs our cleanup actions. EM continues to pursue its cleanup objectives safely within a framework of regulatory compliance, and the Department has 19 sites currently listed on the EPA's national priorities list. EM is responsible for the cleanup of 11 DOE NPL sites, which are located across 7 states. Under CERCLA, EPA oversees the Department's cleanup actions at NPL sites, and although states are not a delegated authority for oversight of DOE's NPL site cleanup under CERCLA, state regulators are active participants in the CERCLA process. We work with EPA and the states to determine site priorities, evaluate cleanup approaches, develop a schedule for cleanup activities, and specify the requirements the site cleanup actions and activity must meet. These collaborative decisions are memorialized as binding commitments in a federal facility agreement or a tri-party agreement between the state, EPA, and DOE. And these regulatory frameworks set cleanup standards and govern our cleanup activities. Generally, cleanup levels are directly tied to the expected future land uses of our sites. We have nearly 40 agreements at the 16 sites where we are working. Largely, EM has had success working with state regulators when it comes to negotiating, updating, and improving compliance agreements. Our site office have weekly, often daily interactions with our regulators, state and EPA, to keep them apprised of site activities. We also currently have one Federal Advisory Committee Act chartered site-specific advisory board with 8 local advisory boards organized under that umbrella. Members of these advisory boards include people directly affected by site cleanup activities, such as stakeholders from local governments, tribal nations, environmental and civic groups, labor organizations, universities, industries, and other interested parties and citizens. A collaborative relationship with state and federal regulators and the public is essential to successfully completing our cleanup at our sites. In addition to the collaborative relationships with regulators and stakeholders, there is also a need for continued investment in research and development for our program. We believe through strengthening the scientific basis for decision-making, the improvement in the effectiveness of cleanup technologies, as well as development of new technologies that address difficult and one-of-a-kind unique issues and challenges, it's our hope that the costs and project timelines can be reduced. Mr. Chairman, Ranking Member Tonko, and members of the subcommittee, I'm again honored to be here today representing the Office of Environmental Management. I appreciate your interest in our work, and I appreciate the funding provided by Congress for EM each year. We are committed to achieving our mission within a framework of regulatory compliance, and will continue to apply innovative environmental cleanup strategies and to complete our work safely and efficiently, thereby demonstrating value to the American taxpayers. Mr. Chairman, I know you've had the opportunity in the past to visit the Hanford site, and I believe the Savannah River site fairly recently, and get a firsthand look at the magnitude and the challenges that we face on a day-to-day basis in implementing our cleanup work at our sites. I would invite and encourage every member of the subcommittee to visit our sites, and would be happy to assist in arranging tours and those visits as appropriate. With that, I'm pleased to answer any questions as we move forward that you may have. Thank you.
Thank you very much. Next, I'd like to recognize Mr. John Conger performing the duties of the Assistant Secretary of Defense, Energy Installations and Environment, U.S. Department of Defense. You're recognized for 5 minutes, and welcome.
Thank you, Mr. Chairman. Good morning. Chairman Shimkus, Ranking Member Tonko, distinguished members of the subcommittee, thank you for the opportunity to discuss the Department of Defense's cleanup activities and the progress we've made to date. The department has long made it a priority to protect the environment. From a mission perspective, we want to ensure that we have the land, water, and airspace we need for military readiness. Moreover, we must protect the health of the military and civilian personnel and their families who live and work on our bases, to ensure our operations don't affect the health and environment of surrounding communities, and to preserve resources for future generations. While we're here to talk about cleanup of past contamination, I want to emphasize that we are committed to rigorously complying with current laws to minimize new contamination. Our funding requests, our strong relationships with federal, state, and local stakeholders, and our continued progress reflect that commitment. The Department of Defense is responsible for approximately 39,000 cleanup sites across hundreds of active and closed bases. And if I could, I've heard the term site used by other witnesses, and I think they use it differently than I do. I'm talking about specific instances of pollution. Multiple sites can occur on a single installation. So I think the numbers that I've heard earlier reflect an entire installation would be a single site, and we break it out differently. But in any case, 39,000 cleanup sites across hundreds of installations. In order to make the most impact, we continually reassess DoD's cleanup program to ensure that we address the highest risk sites first, a process we conduct in collaboration with EPA and with the states. At the same time, we're committed to completing cleanup or achieving response complete, no further action required at all of our sites. We appreciate Congress's support for the roughly $1.5 billion a year we spend on cleanup. At this point, more than 80% of our 39,000 sites have reached response complete. I'm proud to say that we remain on track to meet our goals, internally set goals of 90% response complete by the end of 2018 and 95% by the end of 2021. None of our successes would have been possible without investments in groundbreaking research and development in environmental technology. These are aimed at tackling our most difficult cleanups. Recent successes include bioremediation techniques for groundwater cleanup and detection technology to help find buried munitions. We are beginning to focus our R&D on capabilities needed to accelerate cleanup of the complex sites that will remain after we achieve our 2021 goals. Finally, I would like to highlight the contributions of our state, local, and federal partners. State and local stakeholders help us to develop site management plans, play an active role in remedy selection, and have important oversight responsibilities. To that end, we've established 3 high-level working groups and approximately 200 restoration advisory boards for local input to provide forums for local communities, state regulators, and other federal regulators to discuss cleanup issues and concerns with us. We are also committed to interagency efforts. For example, my staff and senior leaders from the 3 military components meet with EPA headquarters staff quarterly to ensure our programs are on track and moving forward. In conclusion, our focus remains on continuous improvement in the restoration program. We have been identifying cleanup sites since the 1970s and have come a long way. Still, we're fully aware of the magnitude of our mission, and we look forward to continuing our partnerships and making smart investments in technology to meet our outlined goals. Thank you again for the opportunity to testify today, and I look forward to answering your questions.
Thank you very much. And again, we welcome you here. Now, Mr. Alfredo Gomez, no stranger to this committee, Director of Natural Resources and the Environment at the U.S. Government Accountability Office. Welcome. You have 5 minutes.
Thank you, Mr. Chairman. So Chairman Shimkus, Ranking Member Tonko, and members of the subcommittee, good morning. I'm pleased to be here today to discuss our work on hazardous waste cleanup at federal facilities. The federal government owns over 700 million acres of land. Some of this land is managed by the Department of Agriculture, Interior, Department of Defense, and Department of Energy, and is contaminated with hazardous waste that poses serious risks to human health and the environment. The cleanup of these sites can require substantial time and expenses, as you've heard already. In response, Congress passed CERCLA, also known as Superfund, which requires owners and operators of hazardous waste to notify the Environmental Protection Agency of the existence of their facilities. Based on the risks a site poses, EPA may place the site on the national priorities list, a list that includes some of the nation's most seriously contaminated sites. And so, as of September this year, there are 158 federal sites on the list. So my statement today summarizes the results of several reports on the topic. I will talk about 3 key points. First, the number of contaminated and potentially contaminated federal sites for the 4 departments. And 2, spending on and estimates of future costs for cleanup at these sites. And number 3, EPA's role in maintaining the list of contaminated and potentially contaminated federal sites and ensuring that preliminary assessments of such sites are complete. The first point is that while the 4 departments have identified thousands of contaminated and potentially contaminated sites, they do not have a complete inventory of sites, in particular for abandoned mines. Specifically, while the U.S. Department of Agriculture had identified over 1,400 contaminated sites and many potentially contaminated sites, the department did not have a reliable, centralized site inventory for abandoned mines. The department's Forest Service estimated that there were from 27,000 to 39,000 abandoned mines on its land. The Department of the Interior had an inventory of 4,722 sites with confirmed or likely contamination. However, the department's Bureau of Land Management had identified over 30,000 abandoned mines that were not yet assessed for contamination, and this inventory was not complete. The Department of Defense reported to Congress in June of 2014 that it had 38,804 sites in its inventory of sites with contamination. The department had the greatest number of sites on the national priorities list. The Department of Energy reported that it has 16 sites in 11 states with contamination, and as you've heard already, the department is responsible for one of the world's largest environmental cleanup programs. Second, with regards to the cost of cleanup at these sites, the 4 departments reported allocating and spending millions of dollars annually on environmental cleanup and estimated future costs in the hundreds of millions of dollars or more in environmental liabilities. For example, the Department of the Interior allocated for fiscal year 2013 about $13 million for environmental cleanup efforts and reported $192 million in environmental liabilities. The Department of Energy received annual appropriation of about $5.9 billion in fiscal year 2015 to support cleanup activities, and in 2014, the department estimated its total liability for environmental cleanup at almost $300 billion. So third, as of August 2015, EPA had compiled a docket of over 2,300 federal sites that may pose a risk to human health and the environment. EPA has noted that it is difficult to know about a site if the agencies have not reported it. EPA is also responsible for ensuring that federal agencies assess the sites for contamination and has established 18 months as a reasonable time frame for agencies to complete preliminary assessments. However, some agencies may take 2 or 3 years to complete an assessment. So in summary, there are thousands of contaminated sites, and the list is not complete. The 4 departments have spent millions annually for cleanup and have estimated future costs in the billions of dollars. And lastly, EPA has compiled a docket of over 2,300 federal sites that may pose a risk to human health and the environment. Mr. Chairman, Ranking Member Tanco, members of the subcommittee, that concludes my statement, and I'd be happy to respond to questions.
Thank you very much. Before I start with my questions, we're going to have 2 panels. The second panel is going to have the states kind of represented, along with another person who we don't know who that is yet. But it was the intent to maybe have it all on one panel so you could hear the concerns posed by the states. And it's my hope that you all will follow up and at least listen to the second panel. There's always 10 legislative or business days with follow-up questions. So a lot of maybe the follow-up questions that we'll present in writing will be based upon the second panel testimony. I think it's going to be instructive and educational, and I hope you pay attention to that also. Having said that, let me start with my questions. Mr. Stanislaus, do you think that Executive Order 12580 in delegating lead cleanup status to agencies that may have caused contamination at a federal facility and which are responsible for paying for cleanups creates a potential conflict?
So all I can really speak about is those sites within our responsibility. So of those sites within our responsibility, we do have an ability, EPA, to oversee that subset of sites. Those are sites on the national priorities list. Other sites, we don't have that ability. It's been delegated directly to the other federal agencies.
So let me ask this again. Do you think that the funding mechanism, okay, so you've got a federal agency, they have a contaminated site, they are, because of the executive order, given the authority for remediation, but the funding also comes out of their own budget. Does that cause a conflict? Does that make it difficult? Do they then are they making cost-benefit analysis based upon budgetary outlays?
Well, I mean, with respect to how the other agencies make that decision, I don't really know. But I can tell you from where EPA is involved in overseeing sites by the various federal agencies, there is really a real value to have independent review of everything from the scope of work and the implementation of the work.
So let me go to Mr. Whitney. This is really the genesis of the questions that I'm going to have for really all the panelists. In the situation where DOE is both the primary responsible party and the lead agency making remedial decisions, can you understand that's the question, that the potential conflict about concern about conflicts and the worry that remedial decisions may be based on budgetary considerations?
Thank you, Chairman. So for the Department of Energy sites, while we are the lead agency for the cleanup, we do not have a regulatory role. That regulatory role is by the EPA and the states. And so, sir, I don't see a conflict of interest. We work very closely and
but you're still the lead agency, whether there's an oversight role or not.
Yes, sir.
Okay. And really, Mr. Congress, same question.
Yeah, no, I don't see a conflict. Most of the contamination that we're cleaning up, it dates from a long time ago, and it's not like there's a conflict at a particular location between the person cleaning something up and whoever had made the spill or whatever. We're pretty successful in getting appropriations for this cleanup. We have a very stable, roughly $1.5 billion a year that we get into this program. We have schedules that have been fairly stable over the years, worked out with EPA in the states. I don't see any conflict or any problems on this.
And let me go back to Mr. Whitney. Just what happens if two different federal agencies assert lead agency authority? And Mr. Conger, you can address it too. For example, if one agency currently owns the property, but another agency caused the contamination, which agency, in fact, has the lead agency authority?
Sir, I'm not aware of that with respect to DOE sites.
Mr. Conger, are you aware of that?
I can think of an example or two.
You can.
But so here's the dynamic where we can cause the contamination and then transfer a property through BRAC or whatever other mechanism. We have a responsibility for cleaning up all the contamination that we know about. That is the dynamic that we're dealing with. We have CERCLA responsibilities and we uphold them.
Yeah, and we're not trying to play gotcha. I mean, a lot of this stuff is way before we were better environmental stewards, more focused on, yeah. and so I mean, this is not an attempt at gotcha. It's just clarifying the record, trying to get answers to our questions. I want to make sure I get to Mr. Gomez for my last question. In your written testimony, you recommend that Congress should change Section 120 of CERCLA to add a deadline for federal agencies to complete their preliminary assessments. Can you explain that? Please explain that.
Certainly. So yes, we did note that in the report. So EPA has essentially set 18 months as a reasonable time frame for agencies to complete preliminary assessments. And what we found was that some agencies were taking 2 to 3 years to complete. So what we suggested then for Congress was that to consider giving EPA the authority to actually enforce that requirement. We don't specifically set what that requirement should be, but we do note that EPA has already set a reasonable time frame of 18 months.
So your recommendation is that the EPA have an enforceable deadline, and in your analysis, you don't really choose what that is?
Correct.
Okay, great. Thank you very much. I appreciate it. My time's expired, and I yield to the ranking member of the subcommittee, Mr. Tonko, for 5 minutes.
Thank you. And again, I thank the chair for convening this panel to provide us with a progress report on federal facility cleanups under Superfund. Last Congress, this committee considered legislation to change the treatment of federal facility cleanups under Superfund. That bill was not based on an oversight record and included several misguided provisions. I did indeed oppose that legislation, as did all of my Democratic colleagues on the committee. So I welcome this opportunity to build the committee's record on these issues and hear from some of our agencies involved in federal facility cleanups. I would like to start by asking about federal responsibilities under current law. Mr. Condra and Mr. Whitney, under current law, are you subject to the liability and cleanup requirements of Superfund at sites where you are a responsible party?
Maybe I'll go first, if that's okay. Yes, sir. The Department of Energy is subject to the same requirements as private entities under CERCLA.
Thank you. And
Yes.
Mr. Condra, you are in agreement. Mr. Stanislaus, under current law, are all federal agencies subject to the liability and cleanup requirements in Superfund?
Yes.
In fact, Section 120 of Superfund imposes additional requirements on federal agencies that private parties do not face, I believe. Mr. Condra, what obligations does Superfund place on the Department of Defense and other agencies before you can transfer land?
Before we transfer, so it's a little complicated. We can transfer land that's contaminated with a guarantee to clean it up after the transfer. We can have that set up in the agreement. We have a responsibility for cleanup regardless of when the transfer occurs.
Okay, and does that is that true also in regard to the BRAC process where we're addressing the realignment and closure of our bases?
Yeah, that is generally true. I want to be careful not to I'm not going to pretend to be an attorney here, and so as we go into the finer points of the law, I'm not going to I'll double check for the record the answers to your questions, but in a broad sense, we have responsibilities to perform the cleanup at BRAC sites or whatever other transferred sites we have. We have on occasion not let that hold up the transfer of property, but rather, with eyes open to whoever's receiving the property, either agreed to clean it up after the fact or made an agreement or arrangement to have it cleaned up after transfer.
And Mr. Gomez, do private parties face these given obligations?
That's something I'd have to get back to you. Also, not being a lawyer, Mr. Tonko, so I have to get back to you on that.
Okay. I'm sure that our ranker, Mr. Pallone, and others on the subcommittee will delve into the details more, but it is clear that there are a lot of potentially contaminated sites on federal land that still need to be assessed and cleaned up. But a good deal already has been done, as I indicated earlier. Mr. Condra, can you describe the progress that DOD has made in cleaning up its inventory of Superfund sites?
Certainly. We and I won't just limit it to Superfund, because we track all of our cleanup sites together in a fairly large, it's 39,000 sites together in a single database. And I could probably break it out, but I don't have that available. I can get that for the record. But frankly, we're complete with cleanup at 80% of our sites. We set fairly aggressive goals a few years ago to get to 90% by 2018. We're on track for that. We're looking at getting 95% of our sites cleaned up by 2021. We'll have some complex sites that are left over at that point. I'm not going to pretend that it's going to be done in a few years at that point, those last 5%. But that's why we use R&D. We attack the difficult problems with some of our research funding to try and figure out how we're going to be able to accelerate timelines or to clean it up better. And when we do come up with something, like the bioremediation techniques that we came up for cleaning up groundwater, that's applicable to the private sector as well, and they use those techniques as well once we figure it out for our own purposes.
Mm-hmm. And Mr. Whitney, can you describe the progress with DOE?
Yes, sir. As I mentioned, we have cleaned up 91 of our sites, and we have 16 sites remaining, but 91 sites in 30 states. We have reduced the footprint, the cleanup footprint in the environmental management, the DOE complex, by 90%. And when we talk about our sites, we talk about square miles and not square acres. And we are down to about 250 square acres, and we were previously near 3,000 square, 250 square miles, excuse me. We were previously around 3,000 square miles when we started with the program. So we've had significant accomplishments across the complex. Now, as my colleague here stated on for DOD, we have some complex challenges remaining ahead of us, and probably the most difficult challenges remaining ahead of us.
Mm-hmm. I see my time is up, so I will yield.
Thank you. Chair now recognizes the gentleman from Mississippi, Mr. Harper, for 5 minutes.
Thank you, Mr. Chairman, and thanks to each of you for being here. And I'm just curious, Mr. Stanislaus, how many times have you now testified before a committee or subcommittee?
I think I should get an honor or something.
Surely.
Okay, so.
Have you kept?
Oh, you're going to get one.
Have you kept up with the number of times? I
have to get back to you. You know?
Yeah, yeah. That was the answer I was looking for. Thank you very much. Mr. Gomez, I'm going to remember that one, Mr. Stanislaus. Mr. Gomez, you just testified, and obviously your 2015 report noted that while Interior and USDA have identified thousands of contaminated and potentially contaminated sites, they don't have a complete inventory of sites. Can you elaborate on that a little bit, and then tell me, how do you remedy that?
Sure. So as I noted in the opening statement and also in our report, Interior and Agriculture have identified thousands of contaminated sites, but their inventory, particularly for abandoned mines, is incomplete, in some cases not reliable. In the case of the Forest Service, the different regional offices have different ways of gathering information. And just one example on the Interior side is, for example, the Bureau of Land Management estimated an additional 100,000 mines that have yet to be inventoried in 3 states, and those are the states of California, Nevada, and Utah. So they have, we believe, quite a bit of work to do when it comes to abandoned mines.
And also, Interior and USDA disagree over some of the docket listings that exist now. Tell us what the disagreement's about, or if that's significant.
Sure. So the disagreement is one disagreement is between EPA and Interior with regards to the overall approach to listing sites on the docket that are not reported to EPA by the agencies. And Interior believes that CERCLA does not give EPA the discretion to list sites unless Interior reports those sites to EPA, and that EPA should limit listing only sites that agencies report to it. Now, both Interior and USDA also believe that abandoned mines should not be listed on the docket. And the idea there is that these are contamination that wasn't caused by the agencies. EPA's view on that is that regardless of whether the contamination was caused by someone else or the federal agency, that these sites are now under the ownership of the federal government, and the federal government needs to take responsibility for it.
So how do we get one list? How do we ever get to one list?
It's a work in progress at the moment.
Okay.
So, and that's why we call attention to it, that we don't think that least, well, the inventories are not complete, and there's disagreement about what should be added to the docket.
And this is not necessarily, assuming we had a uniform list, it's not necessarily static, because you can have new sites that develop or become
Correct. And also, on the docket, for example, the docket also includes sites that no longer need to be addressed. So it has sites that are contaminated, sites that are potentially contaminated, and then sites that don't need to be addressed. So there's no method currently to remove those sites from the docket.
Gotcha.
The docket is more of a historical record.
In your written testimony, you had mentioned that there's a lack of interagency agreements between DOD and EPA. Can you elaborate on that and explain why this could be a problem, or is a problem?
So work that we did a number of years ago where we looked at 11 DOD installations those installations had yet to enter into interagency agreements with EPA. And even though they had already been listed in the national priorities list in some cases for years, and we found that the lack of these interagency agreements had resulted in delays of cleaning up those sites. Now, as of March 2013, when we looked into the issue again, most of those sites had already gotten interagency agreements. There were only 2 that had not. And currently, there's only 1 site that doesn't have an interagency agreement.
Okay. Are there similar problems with other federal agencies conducting cleanups under CERCLA?
So the work that we did had focused on the Department of Defense because they have the majority of national priorities list sites on the NPL. We didn't look at the other sites, at the other agencies, so we don't know if that problem also exists there. Perhaps our witness from EPA might be able to shed some light on that.
Thank you, Mr. Gomez, and thank you, Mr. Chairman. I yield back.
Thank you, Chair. Now recognizes the ranking member of the full committee, Mr. Pallone, for 5 minutes.
Thank you, Mr. Chairman. Superfund cleanups are essential for public health, the environment, and the economic vitality of communities around these sites. Unfortunately, many of these communities, the wait for a cleanup drags on because funds and resources are limited, and the backlog of potentially contaminated sites is huge. So I wanted to ask Mr. Gomez, with that in mind, can you share some recent estimates of the number of potentially contaminated sites on the USDA and Department of Interior, with regard to USDA and Department of Interior?
Sure, thank you. So with regards to the Department of Agriculture, they have identified almost 1,500 sites that are contaminated or potentially contaminated. Also, the Forest Service estimates that from 27,000 to 39,000 abandoned mines on its land, and approximately 20% of those may pose some level of risk to public health or the environment. Now, on the Interior side, Interior has identified over 4,700 sites with confirmed or likely contamination, and the Bureau of Land Management has also identified over 30,000 abandoned mines that were not yet assessed for contamination. And I'd also mention that in addition to that, there was those additional 100,000 mines that need to be inventoried in 3 states.
What about the number of sites under control of Defense or Department of Energy?
Sure. So the work that we did, which was issued in January of this year, focused on the Department of Agriculture, the Department of the Interior. We have not looked at what the Department of Energy or Department of Defense have in its inventory.
Okay. Are there additional federal sites controlled by other agencies?
Yes, there are some, for example, NASA sites that are out there. There was some work that the NASA IG was doing, so we didn't look at NASA in our work.
I mean, these numbers are staggering themselves, not to mention, the departments that you haven't looked at. But I think they're only part of the story. Can you share recent estimates of the cost to clean up these federal sites?
Sure. So the estimates, as I noted also, are in the hundreds of millions of dollars. And just to give you some examples, maybe some examples that I didn't mention, is the U.S. Department of Agriculture, for example, allocated in fiscal year 2013 over $22 million to do environmental cleanup, and then also reported $176 million in environmental liabilities. The Department of Defense spent almost $30 billion from 1986 to 2008 across all environmental cleanup and restoration activities at its installations. And then in fiscal year 2014 financial report, DoD reported $58.6 billion in environmental liabilities.
So, I mean, if you look at the amount of money that's being spent versus what's needed, there's a huge gap, obviously. Let me turn to the 3 agencies on the panel. Are consistent and reliable appropriations important for completing cleanups in a timely manner, in your opinion?
I'll start.
Sure.
I think they are, and I think that's what we've had. As I've noted before, we spend about $1.5 billion a year. That's a very stable amount of money, and we are able to plan with that amount of money. We'll work out schedules with the EPA and the states. Everybody knows the pace of the work that's going to be going on, and I think there's a comfort level with that. So, and just a clarification point on the liabilities, the environmental liabilities that were mentioned earlier. The cleanup liability is smaller than the number that was cited. That's the entirety of all of our liabilities that include all of our nuclear ships and the eventual cleanup for those, and and a variety of other items. But the cleanup liability is closer to $27 billion.
Let me just ask quickly, yes or no, because I don't want to ask one last question. Could more cleanups be completed with greater resources? Just yes, no.
I think that there's always possibilities, but we have a stable program right now, and I think.
How about the other two guys? Yes or no?
Yes, sir. I think it could be we know what our cleanup life cycle is. So I don't know if more cleanups could be completed, but the cleanups that we have could be completed quicker.
And you're, Mr.
Well, I would say yes, and we've been subject to about a 20% cut of our resources to oversee the subset of sites that we have direct responsibility for. So that has, in fact, impeded the pace of work.
All right, let me just ask quickly, because I know my time is up. I just want to know if more investment in federal, I'll ask Mr. Stanislaus, could more investment in federal cleanup efforts lead to the development of new technologies and best practices that can improve the cleanups nationwide quickly?
I mean, I would say generally the answer is yes. I mean, and I think, as Mr. Conger noted, there are unique issues at DOD and DOE sites, so clearly some technologies would help in some cases.
All right, thank you, Mr. Chairman.
Gentleman's time expired. Chair, now recognize the gentleman from Ohio, Mr. Latta, for 5 minutes.
Well, thank you, Mr. Chairman, and to our panel, thanks very much for being here. If I could start with you, Mr. Stanislaus, since I guess you've won the record as being here the most, so I'll start with the questions. Do you believe that current and formerly owned federal facilities should have to comply with the same state requirements as a private entity conducting a cleanup under CERCLA?
Well, I think CERCLA does, in fact, provide for that.
How often let me just follow up, how often do federal facilities comply with state laws and regulations? Is it all the time?
Well, yeah, I could only speak about those that we have direct responsibility for. So we do, in fact, engage the states continuously with respect to their role throughout the process, the investigation, the application of state requirements. So with respect to those sites, the states play a partnership role.
When you say that it depends on what your role is, what's the percentage that you'd be involved in those sites then?
I will get you the exact percentage. It's relatively small because we only have a direct oversight responsibility on just those sites that are listed on the national priorities list, which, as described earlier, there are lots of other sites under the responsibility of DOD, DOE, and the Department of Interior and Forest Service. And,
okay. Let me ask this. Is sovereign immunity often invoked by federal agencies?
Well, we've not found, from our role in oversight national priority, that not been an issue from our perspective, but that's as much as I know.
Okay. And also, do you believe that Section 120 of CERCLA is evidence that Congress intended to waive sovereign immunity under CERCLA and to require federal entities to comply with state cleanup laws?
I may have to get back to that. I don't know the answer to that question. Let me get back to you on that.
Okay, let me ask this then. Do you think that the Section 120 of CERCLA needs to be amended to make sure that the federal agencies do comply with state regulations and laws dealing with cleanup?
Well, again, just within the sliver of sites within our responsibility, we largely have the states as a party to federal facility agreements, so they have the equal rights as EPA. And at least from where we are involved in federal facility sites, we view the states as a partner. I really can't speak to those sites that we don't have a role in.
Okay, thank you. Mr. Conger, if I could turn to you, if I could ask, does DOD recognize and comply with state land use control laws and regulations related to environmental cleanups?
So the answer is it depends. It's complicated, and my lawyers will, I'm sure, hope that I don't give a simple answer to your question. So I'll take that for the record formally, but let me give a sort of first-level answer to the question. Yes, of course, on those sites that we no longer own. On BRAC sites, on FUD sites, all of that, those are not federal property generally, and so those controls would apply. Where it's federal property, it gets more complicated, and again, not being a lawyer, we'll take that specific instance for the record.
Do you all look at, when you're doing your reviews, do you look at the state land use laws and how that deals with the environmental cleanup?
Yeah, and we are partners with the states when we do our cleanups. And as Maddie indicated, most of the sites that we have, or at least a significant number, are regulated by the state regulators. We work with them. We work schedules out together. We work remedies out together. This is something we do in partnership. I am unaware of significant discontent in the states with how we're doing our program.
Let me follow up with another question, if I may. Would you please describe in detail how DoD measures success, or to the use of the term you used in your written testimony, achieves response complete?
Yes. So in every cleanup, there's a process, as you well know. There's an investigation, which includes the preliminary assessment, the site inspection, the RI, the FS, et cetera, et cetera. The actual remediation, once we have a remedy in place, and once we have conducted all of the operations, all the remedial operations and satisfied the regulators at a particular site, then we have achieved response complete. We'll have some long-term monitoring in some places so that we go back and double-check that the contamination hasn't recurred. But once we've taken all of the actions that we're supposed to take at the site, we achieve response complete.
Just one last real quick question. Do you measure that cleanup then with respect to the acres you clean up, or how do you do that?
With respect to
on the amount of acres you've cleaned?
No, because not everything is about acres. Sometimes it's about groundwater. Sometimes there are a whole variety of ways to measure, so we don't normally think of it just in terms of acres.
Thank you, Mr. Chairman. My time's expired. I yield back.
Gentleman's time's expired. Chair, and I recognize the gentleman from Oregon, Mr. Schrader, for 5 minutes.
Thank you, Mr. Chairman. Mr. Stanislaus, I'd like to kind of move, in our area, where one of the biggest sites we have to deal with is the Portland Harbor. There's a Superfund site, and the defense industry, big partner in contaminating that during World War II, and now not so much of a partner in cleaning the thing up at the end of the day for a lot of the reasons that have been mentioned here. But I'm concerned about EPA's approach to that harbor. You've got a number of businesses that have stepped up, formed this lower Willamette group, trying to figure a way to actually clean this up or be a partner in cleaning it up without the federal government, frankly, at this stage of the game. And I'm worried about the science that's involved in this. Particularly, I guess I want to know from you, is it common practice to do a qualitative and not a quantitative analysis of the cleanup alternatives?
Well, I think we have, in fact, done a quantitative analysis.
Well, see, I would disagree with that. There is not a quantitative analysis done. In the report I saw on the feasibility study, there's no evaluation of what the concentrations of various contaminants would be after different remedial actions have been taken. I think most of the businesses, they're going to be funding this. Anybody that's doing any scientific analysis, you're supposed to do a cost-effectiveness analysis. Once you've determined the health risk, then what are the most cost-effective ways to take care of this stuff? And that's not what I'm seeing in the report. I guess I'd like you to get back to me with that information where there's a quantitative analysis of that. The other question I had was regarding natural recovery. Is it common for natural recovery to be ignored by EPA when they do remedial action analyses?
No, if I can give a broad answer. So we've conducted a remedial investigation which identifies...
I'm asking about natural recovery.
As part of the alternatives analysis, we would look at the various alternatives, including that kind of alternative.
Well, I appreciate you saying that, because that's not what's done in this particular feasibility study on the Portland Harbor. The natural recovery aspects, the quantitative aspects of what natural recovery are not being included at all. Matter of fact, you can't, I would argue respectfully, scientifically evaluate, how a particular remedial action, capping, dredging is going to work, what benefit you're going to get from that, unless you know what the natural recovery benefit is going forward. Matter of fact, just down the river, or up the river actually at Willamette Falls, there's a site that was grossly contaminated as a paper mill, and environmental agencies have determined that it does not pose any real contaminant risk because natural recovery has completely wiped that out. Admittedly, it's a higher flowing river at that particular point. So I'm not seeing that going forward. The other thing I'm worried about is, in this particular case, is how they've evaluated these alternatives. Is it normal for EPA to assume that dredging is going to go on 24 hours a day, 6 days a week in a water work window? Is that the normal way you would evaluate?
Well, it'll depend on the facts of the particular circumstance. So we evaluate alternatives, be it.
Would you assume that that the dredging operation would go 24 hours a day, 6 days a week in a recovery action?
Well, I can't say a generalized rule. It will depend.
I think most people. I apologize for interrupting you, but I would say most people would say that's unrealistic. That's not the way any operation works at the end of the day. And what happens with that is then you're underestimating the costs of some particular remedial actions. And I see that in this particular feasibility study. I think that's unfair and unrealistic, and you end up skewing the results of your feasibility study and the effectiveness of different remedial actions when you do that. Question also on principal threat waste. How do you determine the levels of different contaminants so that they constitute a principal threat waste? What procedure do you use?
Yeah, let me get back to you on that regarding that. But the whole purpose of the draft feasibility is actually to entertain.
The reason I asked that particular question, again, sorry to interrupt, I want a limited amount of time, is that I think that's important. What we're seeing here now is that there's low and unprecedented levels, I'd argue, of determining these principal threat waste levels in this feasibility study for the Portland Harbor. And as a result, you're doing treatments in addition to removal, in addition to capping. I mean, without any analysis, does that treatment of this so-called principal threat waste going to give you an additional benefit? Again, the science that I see EPA not using in this group and with these willing set of businesses wanting to step up and do the right thing without any federal largesse, and they're being cast aside. I think it's a terrible reputation that EPA is developing, unfortunately, in our region, and could drive the cost. We've heard costs of hundreds of millions of dollars. The whole defense industry, maybe $1 billion a year. They're talking billions of dollars for this one little Superfund site, and I think that there's estimates by others that it could be in the millions to maybe hundreds of millions of dollars. So there's a big difference, respectfully, between what EPA is looking at and the assumptions they're using that reasonable business and scientific experts would get to do the same amount of cleanup at the end of the day. So I appreciate getting back to me on some of that information.
Yeah, I will get back to you, and I can assure you that we've discussed the science with all the stakeholders. In fact, we really appreciate the responsible party stepping up. From the very beginning of the process, we looked at the scope of the science, conducted the science in an open and inclusive way, and we will continue to do so.
Gentleman's time expired. The chair now recognizes the gentleman from Ohio, Mr. Johnson, for 5 minutes.
Thank you, Mr. Chairman, and I want to thank the panel for being here. Mr. Stanislaus, I was thinking earlier as we were talking about how many times you have testified. If this were baseball, your number of at-bats and your own base percentage would be one of the highest in the league. So I commend you for continuing to step into the batter's box. I know these are tough issues. Mr. Whitney, I represent many of the hardworking people that are helping to clean up the former Portsmouth gaseous diffusion plant in Piketon, Ohio, and many others who are dependent upon that work getting done so that they can reindustrialize that site and make it a productive, job-creating site for the people that live there. I'm shocked that the Department of Energy has now extended the deadline or the timeline for completing that cleanup approximately another 30 years. Makes absolutely no sense to me. The people who the commitments were made to, many of them could possibly be dead by the time the Department of Energy gets done doing what they committed to do. And it's very unfortunate that for the third year in a row, jobs are at risk because the administration has failed to request adequate funding to complete this work. The Ohio delegation has repeatedly urged the administration to present a fully funded, comprehensive plan for decontamination and decommissioning activities at the site. Unfortunately, financial instability continues year after year. Back in May, the House of Representatives approved full funding, $213 million for D&D operations, which surpassed the administration's request by $48 million. And yet we see this dragging out process again. We're ready to work with the administration and you folks again this year on funding, but we got to have a willing partner here and a commitment on the part of DOE to move this project forward and meet the commitment, stand up and honor the promises that were made to the people of Southern Ohio. So with that said, what are DOE's plans to address this issue?
Thank you, sir. Yes, and we are committed to the cleanup of Portsmouth, and it is unfortunate that warn-out notices had to be issued at the end of August. Our request for 16 is actually a little bit more than the President's request for 15 for Portsmouth, and it's about $227 million for 16 in our request. Unfortunately, the request, as well as the House, even though the House mark was a very large increase over the President's request, and the Senate mark did put us in a position where we had to provide funding guidance that was lower than the 15 request. Now, on top of, as you know, sir, on top of the $227 million request, we were able to take advantage of barter of uranium, which probably the proceeds, depending on the price of uranium at the time, is another $160 million approximately. So that's almost a $400 million investment in the.
I get that. I get that. But see, the citizens of Southern Ohio, they were not party to developing the formula that determined how this was going to be funded. They were the recipient of a promise by the federal government and the Department of Energy. I think the Department of Energy has a responsibility, as does Congress, to work together to figure out a formula. And I understand that the sale of uranium has caused a wrinkle, but we need to resolve the wrinkle and develop a new formula if we have to, and not make it at the expense of the workers and the folks that live there. So. You know, I would urge you to take back to your leadership, at least from my perspective, and I can't speak for all of the Ohio delegation, but I feel very, very certain that they would agree. This is unacceptable to think and ask the people of Southern Ohio to wait another 30 years to trickle this process along. It's just not right. Okay. Mr. Conger, in your written testimony, you state that DOD works together with federal and state environmental regulatory partners to prioritize sites for cleanup based on worst first. Would you please explain the process that DOD uses to determine which sites are the worst?
So generally, it's a risk-based process that is looking at the risk to human health and the environment. Well, I say generally. I've heard the term risk plus, and what that means is there are other factors that we take into account as well. If there's a low-risk site that happens to be co-located with a high-risk site, we might do them both because it's economical to do them both at the same time. So that low-risk site might be lumped in and done earlier. But generally, as we rack and stack this list, it's based on risk to human health and the environment.
Okay. Mr. Chairman, I got a lot more I could ask, and I appreciate the committee's indulgence to ask that first question, but I yield back.
And gentleman knows that you can submit questions for the record in written form, so thank you. Chair now recognizes the gentlelady from Colorado, Mr. Gett, for 5 minutes.
Thank you, Mr. Chairman. Thanks, everybody, for coming today. As you know, in Colorado, we not only have contaminated federal munitions and chemical sites, but we also have legacy mines on federal lands. And there's often questions of liability regarding the abandoned mine lands, since many companies might have had those properties over the course of decades. Of course, a prime example of this is the Gold King mine, which we saw this summer. And this is what You all saw this on the national news. This is what the Gold King mine looked like. This is what the Animas River looked like. Why those people are kayaking there, I don't know. but the Animas River was orange as it flowed down through Durango and down into New Mexico. And Cement Creek was also turned orange. So this is kind of the backdrop for the questions that I'm going to be asking today. I want to ask you, Mr. Stanislaus, if the EPA is going to be pursuing reimbursement from the companies that left these millions of gallons of contaminated water at Gold King Mine to pay for the remediation of the site.
Yes.
That's good news to hear. I'd like to kind of know if there were private owners, which there were, of that site and the adjoining mine, why was the EPA cleaning up this site in the first place?
Because there was the risk identified by the state of Colorado and the stakeholders that the state of Colorado and stakeholders identified that risk to be addressed immediately. Roughly about 330 million gallons on a yearly basis was going to the Animas River.
And that's before it all came,
That's right.
came rushing out and turned the river orange. Now, that site was not listed on the Superfund National Priorities List, correct?
That's right.
What the National Priorities List does, it targets the cleanup of sites without viable responsibility orders, and it puts it in priority for funding. Is that right?
That's correct. I mean, it identifies those sites that have the most risk in the country. It also makes that site eligible for Superfund resources.
And do you think the Gold King mine would be a candidate for the National Priorities List?
There have been discussions, and I was just in Silverton last week at the invitation of local stakeholders to continue that conversation.
So the decision has not yet been made?
No, we're continuing to have those conversations.
When do you think you'll make that decision?
Well, again, we're engaged in that conversation. There's also kind of a technical evaluation of data. So we're in the process of evaluating that right now.
So would that be like 6 months, 12 months?
I will get back to you on the time frame.
That would be really fabulous. And what would be even better is if we had a very short time frame to get that on the list. You know, there's thousands and thousands of mines, as all of you have said, that are similar to the Gold King mine across the West. Mr. Gomez, in your testimony, you note that both the USDA and DOI have significant inventories of abandoned mine that could potentially pose threats to the health and the environment. Do either of these agencies have a system for prioritizing their most contaminated mines?
As they go through the process of identifying the mines, and they're making their own assessments of it. But we didn't look specifically at that process. We were looking mainly at identification. Those are good questions that we can follow up with.
I'd appreciate that, because it's my understanding that they actually don't have a priority list, and that would be really helpful. Gold King is the perfect example of a mine where everybody knew it needed to be cleaned up, but I think everybody could now stipulate that in hindsight, the preparation for the cleanup, the recognition of the seriousness of the problem was grossly underestimated. Now, based on GAO's analysis of contaminated sites on USDA and DOI properties, do each of the agencies have sufficient environmental expertise of their own to plan and oversee cleanup of the sites?
So for those cases that do end up in the national priorities list, EPA does oversee those sites.
Right.
And so EPA does provide that expertise.
To USDA and DOI?
Do they have that expertise?
Right.
Again, that's something that we weren't looking at the workforce of the agencies to see if they have the expertise or not. But as I said, for those sites that end up in the national priorities list, EPA is doing the oversight.
Okay. Now, I want to ask you, Mr. Stanislaus, it's my understanding that USDA and DOI don't want mines that were Superfund cleanup to be listed on the national priorities list. Does that impede the EPA's ability to oversee and ensure proper cleanup at the sites?
Yeah, our only ability to oversee sites are those sites that are on the national priorities list.
Okay, so if they're not on that list, then we can't clean them up. So I guess, Mr. Gomez, I'd like you to supplement your testimony to see what, in fact, the position of those two agencies is putting their mine sites on that list.
Okay, would the gentlelady yield?
I'd be happy to.
So we invited...
At a time.
That's right. I'm the chairman.
Yeah. Seize control.
We invited the Department of Interior to testify. They, in essence, said they wouldn't. They did say they would submit a statement for. They only sent it when we reminded them that they said they would send a statement. So maybe some follow-up on the Department of Interior might be appropriate.
Yeah, Mr. Chairman, I think that's a great idea, because if you can't list these on the list, then the agency with the expertise to clean it up won't be able to do it. Thank you.
And maybe they'll reconsider coming back next time we ask them. So thank you. Now I'd like to recognize my colleague from North Carolina, Mr. Hudson, for 5 minutes.
Thank you, Mr. Chairman. I'd like to thank the witnesses for being here today. Really appreciate your testimony. It's been very informative, helpful for me to understand this process. I'd like to start with Mr. Conger. What percentage of DOD's hazardous waste facilities have been identified on the Federal Facilities Hazardous Waste Compliance docket as required in CERCLA?
So I can't tell you what percentage of our sites are actually on the docket, because we track all of them as a larger group. The 39,000 sites that I've talked about during my testimony include those on the docket, but we have far more sites than those that are on the docket. We did a couple years ago, we did a docket scrub, went and looked at our database and EPA's database, the docket, to make sure that everything that needed to be on the docket was on there. And so we've done that reconciliation, but I couldn't tell you out of all the sites we have exactly how many are on the docket.
Would you mind following up with us with that number?
Sure.
I'd appreciate it. What percentage of DOD sites that you've identified have the required preliminary assessments been completed on?
Well, out of the 39,000 sites that we've got, I think only 4% of them are still at the preliminary assessment and site inspection phase. The breakout between PA and SI, we can get you, but so I would say by definition it's less than 4% are still in that phase.
Great. For those that you've completed the required assessment, have copies of those assessments and other relevant information been provided to the state and to EPA?
Absolutely.
Great. What's the typical, on average, length of time it takes for DOD to complete one of these initial assessments?
So I actually pulled the data out of the database because I saw that question coming. We have an average of 1.6 years for a preliminary assessment out of all the sites that we've got in our that we've cataloged.
So you would disagree with the assessment from GAO that it takes 2 to 3 years typically?
It can. So that's an average, 1.6 years. There are sites that are longer without a doubt. It depends on the complexity of the analysis that you're doing. So some are shorter, some are much shorter, some are longer.
Gotcha. If Congress were to establish a deadline, as has been recommended for completion of these assessments, would that help DOD complete these in a more timely fashion, or do you think it's more just a factor of the complexity of it?
I think it's a factor of the complexity. I don't have a lot of folks coming back to us and saying that we're dragging our heels. We work out these schedules with the regulators, and so I think everybody is comfortable with the pace at which we're doing the assessments.
Well,
if
thank
there
you
are
for
specific cases, we can look into it.
Thank you. Mr. Whitney, I'll sort of go down the same line of question with you. What percentage of DOE hazardous sites are actually on the list?
Yes, sir. I think it's a little easier for DOE because we do know the universe of our facilities, and while the sites are large, the number of sites are not. And so all of our sites have been through that preliminary assessment process, the site evaluation process, and they either ended up on the national priorities list or they did not.
Great. Well, for those that have gone through and completed the assessments, have copies of those been passed on to the relevant agencies, state, EPA, others?
Yes, sir.
Great. And how many of the sites that have been assessed required some level of cleanup?
The 21 sites that were on the national priority list, all of those sites require some level of cleanup, and we have 11 of those sites remaining. 10 of those have been completed already.
Okay. I appreciate that. Mr. Stanislaus, going back to the issue of the abandoned mines on federal properties, how does EPA oversee the cleanup of these if they're on federal property?
Only those sites that rise to the level of being a Superfund site. So we have 130 on the national priorities list that are abandoned mine sites, but clearly there are a lot more, as other individuals talked about it. So we would only have oversight of just that small number.
Okay. Well, of those, does EPA have a sense of how much contaminated mine drainage discharges from these mines on a daily, weekly, monthly, yearly basis?
I don't have that information in front of me, but I can see what I can pull together.
Okay, thank you. What steps do the various federal agencies routinely take to prevent and stop these types of discharges?
You know, I really can't speak for the other agencies. You know, when we get involved, we would do what's called removal actions, which are kind of shorter-term actions to abate some of the most immediate risks to short-term projects. And when there are longer-term risks, looking at listing on the national priorities just for a more permanent solution.
Gotcha. What are the impacts on stream water quality from these discharges?
Well, tremendous. In the Gold King mine, about 330 million gallons were being emitted into the Animas River on a yearly basis. Basically, for a 10-mile distance on the Animas River, you basically have severely degraded water quality. Basically, fish survival was seriously compromised.
So who's legally responsible for cleaning up when you have these discharges on these sites that you have the jurisdiction over?
Well, when we have jurisdiction over that, we oversee the work. Sometimes it's by responsible parties, sometimes through Superfund resources. And it's the complexity of these sites, it makes it quite challenging.
So who's legally responsible?
Oh, who's legally responsible? I'm sorry. If there's a responsible party, meaning the owner or operator, that party would be responsible for doing the cleanup.
Great, thank you. Mr. Chairman, I believe I've exceeded my time.
Your time is expired. And just a point of clarity, this Executive Order 12580 is kind of an answer to why we have, and Matthews is talking about items on the national priority list, but there are many that aren't on there. And then the question is, who's responsible for those? That's part of the hearing. Now I recognize the gentleman from Texas, Mr. Green.
Thank you, Mr. Chairman and Ranking Member, for holding the hearing on Superfund today. I represent a district in Houston, and up until recent redistricting, I had my district bordered in East Harris County on more significant Superfund sites on the San Jacinto waste pits, bordering our district. At that time, Congressman Poe had the site, but I got the downstream. And EPA was very quick in putting it on the Superfund site. The site's been polluted since mid-'60s as a dumping ground for paper mill waste and was left undetected for over 40 years. The local community is very concerned about the fears it may negatively impacting human health and the environment. My questions are, Mr. Stanislaus, what opportunities will communities in East Harris County have to give input on the proposed cleanup plans?
Opportunity throughout the process.
Okay. Dioxins are the primary hazard at the waste pits, which were used during paper production process 50 years ago. Mr. Stanislaus, has EPA taken any action to limit the use of dioxins and similarly dangerous chemicals in paper production?
Limit the use of dioxin in paper? Yeah. Well, that's outside of my office, but I'll get back to you on that.
Okay. Does EPA have a timetable for when the feasibility study report would be released?
Yeah, I don't have that timetable, but I should note that we put in place certain measures to abate the release of dioxin from the site itself.
And I've been there. It's encapsulating. And what happened, because of subsidence in our area over the last 50 years, those containment facilities may have been great in 1965, but the subsidence, we actually have some of those containment facilities that are below water level in the San Jacinto River, and so far there's different evidence that the encapping of it is working. I think the last test I showed, it's doing well. What are the primary factors for EPA in its determination for the cleanup of waste?
You know, the exposure and the various options to address that exposure. In some cases, we would completely clean it up. In other cases, they put a barrier to prevent further. It all depends on the factors at the site.
Is EPA taking under consideration the vulnerability? The site actually can be flooded because it's a tidal river, but over my lifetime, we've also had floods coming down the river, and so it can dislodge it. Is that part of the EPA study also, the danger of a hurricane coming in or floodings upstream?
Well, typically we would look at all those factors, but let me get back to you specifically how we've considered that at this site.
I appreciate it. The site's now in Congressman Babin's district. It's a neighbor of mine, and you know, we're getting him the information that we've been working on for a number of years. These are questions for all the agencies on the panel. How does your agency ensure that states and local communities are involved in every state of the cleanup under your control?
I can start. We work closely with the state regulators. As Maddie had pointed out, a lot of our sites are overseen directly by the state regulators. So we work with them on remedies and on timetables. We also have restoration advisory boards that we set up with local communities and to make sure that everything is transparent so that they know what's going on. It's very important for us to work with local and state stakeholders.
Yes, and we have a variety of avenues to achieve that type of involvement as well. First and foremost, the states, of course, being co-regulators on the cleanup that we do at our sites, but we are that relationship with the local communities and other folks in the state is also very important to us, and we have site-specific advisory boards made up of citizens of the surrounding communities around our sites. We also provide grants to many organizations such as ECOS, the Environmental Council of States, such as National Governors Association, the State and Tribal Governors Working Group.
I only have
many
a
of
few
these
seconds.
that we work closely with.
I need to get one more question in, though. If a state preferred one cleanup remedy over another, how would the preference influence the decision over the cleanups? Would the federal government defer to the state agency?
It truly is a tri-party. For us, it's tri-party. It's us,
So it's a
EPA,
cooperative issue?
Yes, sir.
Okay. I appreciate it, Mr. Chairman. Thank you.
Let me just chime in with your last 10 seconds. I think what we've heard is everyone views the states as a partner, but no one is required to treat the state as a partner. And that's part of what our hearing is trying to get to. So with that, now we'd like to welcome a member of the full committee, not on the subcommittee. We welcome here to the subcommittee Mr. Lujan from New Mexico, and you're recognized for 5 minutes.
Thank you, Mr. Chairman, and thank the ranking member for holding this important hearing today. As you all know, where this breach ran into was in the 3rd Congressional District of New Mexico, into San Juan County, into the Animas River, which flows from Colorado to New Mexico, as well as to the Navajo Nation, and to our brothers and sisters out in Utah and Arizona, as well as Colorado, that were all impacted. One of the concerns that I had as we began to learn about this issue, it wasn't through an alert from law enforcement officials, from officials that worked for the federal agencies. It was through a news feed, maybe even been a Twitter feed, that our office was alerted to. And so we need to figure this out to make sure that when there's disasters like this that are created, and created by people, as opposed to a natural disaster that flowed, that everyone's alerted promptly and timely. Since this incident, it appears that the state of Colorado is working to improve their communication systems to local governments, but I'm not certain that we have seen what we're going to do with the EPA, with the alert system, and for that matter, for every federal agency, that there could be a system like this that sadly could hurt communities with the mistake that's made. So, Mr. Stanislaus, according to an EPA memorandum, the release occurred on August 5th at 10:51 a.m. However, EPA headquarters, Region 6 and Region 9 were not notified until 11 a.m. the next morning. I just shared that my office found out through news accounts. San Juan County officials, Navajo Nation, leaders in New Mexico, the Environment Department, were not notified. They found out the same way that we did, is my understanding. So that's unacceptable, and we need to fix this and learn from this. So what are we doing to improve notification procedures down to downstream communities as well as impacted communities? One of the suggestions that I shared with Administrator McCarthy yesterday was looking to see what we could do to piggyback off of the Amber Alert system for abducted children, or to the National Natural Disaster Alert System and Weather Disaster System, which notifies everyone with their mobile phones on billboards as everything happens. There's no reason that when something like this that tells people you can't drink water, you can't get in the water, you can't water your animals, you can't irrigate, that we can't use something like that. So can you share a little bit with what we can do and how we might be able to work with you, with the committee, to see what we could do to work with a system like that for alerts in the future?
Sure. Immediately after the event, I issued a directive to all the regions to work with states and local communities to make sure the notification is broad. So we currently have a notification system in place, and in the state of Colorado, we have a plan in place where the state of Colorado took leadership of notifying. They, in fact, notified Durango and other folks, and those decisions were made to close off the water intakes. And you are entirely correct that the notification for New Mexico, for the Navajo Nation did not occur simultaneously, and we agree we need to do a better job of that.
It didn't occur for days.
It occurred the next day. Yeah. And just to be clear, all the notification occurred before the spill impacted any of those areas. In fact, we were able to do pre-incident sampling before any of the impact of the spill occurred in any of those areas.
Ute Mountain tribal officials are the ones that reached out to their neighbors in San Juan County to say, this spill is passing us, you need to get ready for it, it's coming our way. That wasn't an alert system that was put in place. That was one group of neighbors caring about another group of neighbors and doing their due diligence. This was a dismal failure from a communication perspective, and we have to fix it. I hope that the urgency for this, not just here, but in any other part of the country, we need to just get this right so that people know what's coming their way. The other urgency that I would suggest is we need to make sure that we're working with all of the impacted communities to the utmost degree. Both of the Ute tribes that were impacted, the Navajo Nation, the county of San Juan in New Mexico, the state of New Mexico, as well as with our brothers and sisters in the other impacted states. There's been a frustration by the leadership of the Navajo Nation, and we need to make sure that we're working closely with them, that someone's appointed to work directly with them, whether it's from Region 9 or from headquarters, so we can make sure that all of their concerns are addressed. One of the other concerns that I have, Mr. Chairman, is it's my understanding that the EPA's work order at the Gold King mine site called for the construction of a holding pond to capture and treat contaminated water, but that the pond was not completed before the accident. In addition, EPA Deputy Administrator Meinberg said that provisions for a worst-case scenario were not included in the work plan. I think it's important that we understand that we make sure that any time that work will be done in the future, that we get to the bottom of that. And then lastly, Mr. Chairman, as we get an assessment of all of the abandoned mines that we have in the United States, and especially those that are in a condition like the Gold King mine, where a breach or an accident can impact water supplies for millions of people in surrounding communities, we need to have a real conversation in the Congress to make sure that we're working to fix this, because this devastated not just the irrigators and water users in the district that I represent in Colorado, but entire water drinking supplies in the states of Nevada and Arizona that could be impacted depending on the kind of a breach that we see. So just, Mr. Chairman, I look forward to working with you. Thank you for the time today, and I look forward to submitting some additional questions to the record and getting some responses. Thank you, sir.
So I will just add, I share those concerns, and I've actually, and we did an internal review, and the pond, in fact, was constructed for my internal review team. But you know, again, we were there because of the very risk that was identified in the work plan, that the state of Colorado and local stakeholders identified that risk. That's the reason that EPA was brought to kind of address that risk.
But Mr. Chairman, if I may just there, if the pond was built, why didn't it work? Something didn't work. With the amount of stuff that came out of that, which was originally estimated at 1 million gallons, and then it turned out to be 3 million gallons, someone didn't do their job. If something was built, then it wasn't built the right way, because the breach still went, and all this garbage still went into the river. So those are questions that we do need to get to the bottom of. If something was constructed, clearly it did not meet the means of what should have been done with an assessment of what was being held behind there. It didn't work. So according to that mitigation plan, something needs to get better here. And that's what we're just trying to get to the bottom of.
Gentleman's time's expired, and we thank him for his attendance. Look forward to working with him. Again, the opening question submissions for the record for about 10 business days. If you get back to us on, I think there'll probably be some follow-ups. We appreciate it. We've got ways to go. And I do want to encourage you to stay tuned for the second panel, because I do think there is states are, in many cases, good partners and work well. But there are some concerns, as I think we'll hear in the next panel. So appreciate it. And with that, we will recess this hearing. for the second panel next week.